Is there anything else that you want to add or you think is important about this trial? I know it was a long trial, a lot of evidence.
What I think is interesting and has not happened yet is the jurors have not spoken publicly. Now, no one is allowed to reach out and ask for their point of view. That's prohibited here in Massachusetts. Lawyers are not allowed to reach out to the jury, but the jury's free to speak. So in the coming days, I think there may be some jurors who are tempted to say, I want to tell my story. I want to let you know what we were thinking in that room. I don't want people to think we were careless or not reflective. We were, and here's what happened. And if one juror speaks, then maybe another will, and then we'll have a really rich pool of information to figure out what evidence was persuasive and what evidence was a problem.
And speaking out they have. Let's listen to more breaking news.
Good afternoon. According to these affidavits filed here this morning at the courthouse in Dedham, Karen Reid's defense attorneys say that this fourth juror contacted them on Monday. Now, that was the same day that they filed a motion and affidavit saying they'd already been in direct or indirect contact with 3 other jurors. The defense has not released the names of any of these jurors, but says all 4 tell the same story, that the entire jury agreed Reid was not guilty of second-degree murder and not guilty of leaving the scene of a deadly crash. That means they were only deadlocked on the manslaughter charge. This latest juror tells the defense that they thought they had to come to an agreement on all 3 charges before they could report any verdicts. The juror says they were confused and upset that the judge did not give them more guidance before dismissing them in a, quote, whirlwind and declaring a mistrial. Now, based on this information, the defense has already asked the judge to dismiss the murder and leaving the scene charges before Reid is tried again. And so far, Judge Beverly Cannoni has not responded to these defense motions. And the district attorney's office has only said that it plans to file its own motion in this case before a hearing that is scheduled for July 22nd. Live in Dedham, David Beanick, WCVB News Center 5.
It's like, I don't know. There's like a few people. I'm like, I don't understand why the defense wasn't louder about it, because they're not shy. I don't understand why the judge didn't just say, like, which one are you talking? Which of the counts are you talking about? All 3? And I don't understand why the foreman just didn't put in his note, right? Like, dude, we got 2 figured out.
That was Aidan Carney, an independent journalist from the area, aka Turtle Boy, who has brought this case against Karen Reid to the attention of the mainstream media. And on a live I did with other guests regarding Paul O'Keefe's interview, who had criticized the Karen Reid supporters that Turtle Boy and others rallied around the courthouse. What they said about the supporters was, well, you've got to check out our video to find out. Anyway, let's get back to the Karen Reid breaking news. And I had the same question. Was this a botch up, meaning to carry out a task badly or carelessly? And whose botch up was it? To answer this, I am going straight to the Massachusetts Rules of Criminal Procedures. So first, let's look at what the affidavit is saying this 4th juror told them. And we'll start with the court giving jury instructions.
During the course of your deliberations, you might have a question concerning the law in this case. I'm not suggesting that you will, but you might. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officer. Because your role as the jury is to determine the facts of the case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send a question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. We will not answer a question or take a verdict between 1 and 2. You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case.
So the court did give verbal instructions that each member should be in complete agreement of the verdict. After a final vote of the jury, the foreperson should check the appropriate boxes as to each charge. then sign and date the verdict slips and notify the court officer that they have reached a unanimous verdict. In retrospect, from the jurors that have come forward, I can see there are two confusing instructions by the judge that were unforeseeable at the time. One was when the judge tells them not to tell anyone, including her, on how the jury stands numerically or otherwise until they have reached a unanimous verdict. This is a discretion up to the judge when it comes to dealing with multiple charges, and we will discuss this in a bit. The second instruction that I can see now is confusing is the word unanimous, as it has a separate purpose in this context. When the judge said they had to be in agreement with each verdict, then they would be brought back into court to deliver the verdict. One could take that to mean that they had to agree on everything before signing the verdict slips. So the rules on multiple charges allow for the jury, with permission of the court, to deliver verdict slips as and when they have reached a unanimous verdict. However, the court said that the judge said, I only want the verdict slips when you have a unanimous decision on all the charges. So I take that to mean unanimous is when each member is in approval of what they had agreed to. And if they were, for example, at a deadlock or impasse, then they all agree that they are at a deadlock or an impasse. And same is applicable if they all agreed to vote not guilty. This jury is smart. They followed the instructions of the court as they hadn't had an agreement on all the charges. They did contact the court when they were at this impossible impasse. So this juror that came forward to talk to the defense, referred to as juror number 4 in the media and juror number D in the defense's affidavit, said they felt uncomfortable how the trial ended. After the note was read, they were rushed out of the court and they were indeed dismissed immediately. Here is the video I did on that. And the procedure rules allow that the judge may return a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. And I did a community post of this, and this was not done. So maybe the judge doesn't follow these rules. I don't know. I couldn't understand half the rulings that this judge made. And anyway, you can see how breaking this down, how we got here. So what happened to the verdict slips? Because the jury was dismissed immediately. So I was also confused. Did the jury not complete the verdict slips because they thought that they had to be unanimous, i.e. not guilty or guilty on all charges before they could say that they were unanimous? So I think it's a good idea just to look at how the charges were written, as that might give us some more understanding of how confusing this really is. Okay, so offense 1 is 001, murder in the second degree. They have two choices, guilty or not guilty. Simples. And in offense 3, 003, leaving the scene of an accident resulting in death, easy choice again, guilty or not guilty. So if they were unanimous, why were these two forms not signed and returned before the judge declared a mistrial? Let's go on to the next one. Oh boy, offense 002, manslaughter while operating a motor vehicle under the influence. The choices are slightly more complicated. Not guilty is 1 under the charge. However, the rest of the questions, 2 to 4, all have guilty choices with sub-choices requiring them to check one or both of the options. This is according to the juror that spoke out, where they were at an impasse. And the jurors that reached out to the defense said they had not come to a unanimous decision on the lesser offenses, And at the bottom, it requires a unanimous decision from all jurors. Wow, that is a lot to expect. 12 jurors to agree on the different combinations that you can see. And were they expected to sign and not tick, or not tick and not sign because they couldn't agree? Okay, come with me here, because I think we have to go back to the jury instructions, because I thought to myself, well, maybe the court, when they were given the written instructions, it was a bit more detailed. But let's listen to what the judge had to say.
I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud.
In the defense's affidavit, they also say that the juror told them they were very confused as to how quickly the court dismissed them after declaring a mistrial. So let's have a watch of that. And let me know if you think it was very quickly, because the jurors said that they were on the bus soon after and they were all very confused. So let's have a watch.
Rise for the jury. Court is in session. Please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
I know I wouldn't want to sign anything that I didn't agree to. Could the parties have foreseen that the judge would not ask for the verdict slips? Could the parties have foreseen that the jury, by following the court's directions, would take their final note of being at an impasse to mean that they had not agreed on all accounts, all the charges? And when they were rushed out of the court, did this confirm to the jury that, because they hadn't agreed on all charges, this meant that it would be a mistrial? There is no rule that before giving the Tui Rodriguez charge, you'll remember that when the jury came back and said they couldn't reach a verdict, the court, sent them off with this charge to keep trying. Could the court have given that direction then, to say, look, what is there anything that you've agreed on? Can you give me something? She didn't say that, and there is no rule that she has to, because it's supposed to be said prior to calling a mistrial. So, what do you think? Wait, you might ask yourself, why not poll the jury? Polling the jury is a little different than asking them, is there any of the charges that you can agree on. So polling the jury is normally after the verdict has been said in open court, and they go through the 12 juries and confirm, that that is their decision. So, yeah. Now, the judge has that discretion in the Karen Reid trial. However, there was not a verdict given. So, we didn't expect the jury would be polled at that time. The issue we have now is that the affidavits from the defense basically are saying 2 jurors have directly contacted them saying that they did agree to a not guilty and that was their unanimous decision on counts 1 and 3, and if true, because don't forget, statements made out of court are hearsay until said under oath in court. The issue we have now is that the affidavits from the defense basically are saying 2 jurors have directly contacted them saying that they did agree to a not guilty and that was their unanimous decision on counts 1 and 3, and if true, because don't forget, statements made out of court are hearsay until said under oath in court. So will the court bring them back to question them? At this point, the defense is only asking if they can contact the jurors to do some more investigations. What do you think? Can the judge remedy this error? On what I consider she botched up, she represents the courts, and it was a requirement that the judge on behalf of the court must ask for this information prior to calling a mistrial. I'd never seen this before, and when the court makes an error in law, the trial judge is given the opportunity to make it right. However, I don't know, given this judge, will she do the right thing? Will this be grounds for appeal? Even if the Commonwealth decide that they're not going to go forward, or the DA's offices, they're not going to go forward on the charge 1 and 3, it still is a problem, because if the process would have been done correctly, Karen Reid would have been acquitted, and then double jeopardy would have applied. So I don't think they should settle for just that. I think they need to get this sorted. Wow, what a mess. So let me know your thoughts. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.